Hearing in the appeal, Brent London Borough Council against Risk Management Partners Limited.
Well, Mr. Sumption.
My Lords, the appeal having been withdrawn in relation to the judicial review proceedings, your Lordships are concerned on this hearing only with the separate proceedings against the London Borough of Brent for damages for failing to comply with the public procurement or the public contracts regulations. May I say just a word about the parties and how they fit in, because it's a slightly unusual situation. Brent was initially the only defendant to the damages action, and it is still, formally speaking, the only party against whom relief is sought. However, the London Borough of Harrow, my clients, were joined as defendants to the damages action on their own application, together with LAML, the mutual insurer, in order to be able to make submissions and, I suppose, from the point of view of the plaintiffs, in order to be bound by the outcome. There is, in fact, another action, not before your Lordships, brought against Harrow, and indeed other actions against other London local authorities which were insured by LAML. They are all stayed pending the outcome of this case.
Are we allowed to know what the actions are about? Are they damages actions? Or?
They are all damages actions, yes. Now, in the material respects, Harrow is in exactly the same position as Brent. They both subscribed to the memorandum of LAML as members. They were both insured by LAML in the insurance years 2007 and 2008, thus becoming, in the language of the articles, participating members. Their relationship with LAML was exactly the same. They each had one vote at general meetings. The issues between Harrow and RMP, the plaintiffs, are the same as the issues between Brent and RMP were before Brent settled in August of this year. So the position is that although the statement of facts and issues and the respondent's printed case are technically correct in referring only to the position of Brent, that is the procedural basis on which the matter comes before your Lordships, the reality is that Brent, having settled the entire dispute with RMP, this is now an appeal about the position of Harrow and indirectly the position of other local authorities in the same position as Harrow, who are the defendants to similar actions that have been stayed. Now, my Lords, the issue in the damages action, although legally rather technical, is of very considerable importance to local authorities generally. As a result of the decision of the Court of Appeal, the law was changed by statute to give local authorities power, which it had previously been thought that they already had, to make arrangements for mutual insurance of much the same sort as were made in this case. However, the practical value of that change depends on whether they can do it consistently with the public contracts regulations. There are also, it's fair to say, ramifications well outside the domain of mutual insurance. Local authorities are increasingly looking at the provision of services and the procurement of goods and services through subsidiaries, such as staff-run mutuals or other joint entities collectively controlled with other local authorities. This is a trend which began relatively late in the United Kingdom, because the relatively large size of local government units in the United Kingdom makes it economic for them to do a very large number of things on their own without cooperation with other authorities. It's a tendency which began in countries like France and Italy, where local authority units are relatively small, but with the growing costs of the services that local government supplies are of growing interest to United Kingdom local authorities as well. Now, my learned friend Mr. Howell and I are agreed that the printed cases disclose 5 issues before your Lordships. First, whether the Tekau exception applies to the English implementation.
Sorry, are you not going to take to us 5 issues?
I'm going to tell your lordships what it is I think common ground the 5 issues are.
And are they set out in the agreed statement?
They are an expansion of they're all covered in the statement of facts and issues.
I know, but you've now crystallised them, so I think we better get them dictated.
Well, they will be found in my learned friend's printed case.
Paragraph 8?
Sorry?
Paragraph 8?
Yes.
What, 3A and 3B being numbers 3 and 4?
Yes.
And those are the 5?
Yes. Now, the courts below decided most of those issues in favour of the defendants. They held that the TECAL exception was part of the UK regulations. They held that they applied as much to insurance as to other types of contract. They accepted that in the case of a consortium company like LAML, collective control was enough to satisfy what has been called the control test. But they held that the control test was not satisfied, even on a collective basis, primarily, although I'm simplifying the reasoning below in saying this, primarily because the powers of management over LAML were vested in its board, whose members owed the usual fiduciary duties to the company rather than to the participating local authorities who nominated them. Now, since that is, of course, invariably the case with limited companies, that decision has obvious implications for any attempt by local authorities to use corporate vehicles for the performance of any of its functions, particularly when they use corporate vehicles that are designed to enable them to cooperate with other local authorities. Now, my lords, the legal background requires a little introduction. The procurement...
I'm sorry, I'm just... Sorry. But an issue 5, whether the second condition was satisfied, I mean, are you saying you won 1, 2, 3 and 5 but lost 4?
My lord, issue 4, as listed here, was not decided because it was decided that I had failed on the control test, so that the function test didn't need to be considered.
I'm sorry, issue... Well, I'm sorry, I've renumbered them.
Yes, I will use your lordship's numbering.
Well, if you use my numbering...
that's issue 5.
So you won the first 3, lost 4th, and they didn't decide the 5th?
That's exactly right.
That's right. Did the Court of Appeal... The Court of Appeal didn't deal with it, did it?
The Court of Appeal did deal.
The Court of Appeal said obiter that they, without deciding...
Found against who? So you won on 1, 2, 3 and 5 and lost on 4?
My lord, they left 5 undecided, but they said that had they decided it, they would probably have been in my favour.
Oh, all right. You win 1, 2, 3 and half of 5.
Yeah, so the critical one is issue 4.
The critical
From
one,
your point of view.
the one on which I lost, is issue 4.
But we have to get past issue 1, of course, to get anywhere at all.
Well, indeed. And of course, not all of those are issues of European law on any footing. In particular, the question of incorporation, issue 1, is not. Now, my lords, the procurement of goods and services by public authorities accounts for a significant proportion of the gross domestic product of the European community, more than 16% in 2006, according to the explanatory memorandum which accompanied the publication of the English regulations. The object of the procurement regime at a European level is to ensure that where public authorities procure goods or services from third parties, potential suppliers have a fair and equal opportunity to obtain the business and are not frustrated by preferred suppliers who may not necessarily be offering the best available terms. The EU procurement regime imposes obligations on public authorities relating, very broadly speaking, to 1, the public announcement of opportunities to contract, 2, the process of selection, generally but not invariably by public tender. And 3, the criteria for making the ultimate selection among potential suppliers. Although the main driver behind the procurement regime is the need to prevent public bodies from discriminating against suppliers in other member states, the regime is not in fact confined to cross-border procurement. There are very rare cases where it is possible to show that the possibilities of supplying a particular contract are wholly confined within one member state. And in cases where the treaty provisions apply directly, there is at least one case in which that has been held not to engage the procurement regime at all. But that is a very rare situation because, as has often been pointed out in the cases, and your lordships will see those, any system of procurement which discriminates in favour of a preferred supplier will in practice frustrate both national and foreign suppliers, and any legal rules designed to counter that by imposing fair procedures will equally benefit both categories. Now, the European procurement regime is, in its details, very complicated, but conceptually quite straightforward. It is important to both sides' arguments on this appeal to note that there are 2 parallel sources of European law relating to public procurement, namely the treaty and the directives, both of which apply to transactions with public bodies. The primary source of law on this subject is Article 28 of the treaty in relation to goods.
Now, your numbering is from which
Yes,
version?
I am going to use the numbering as it existed before December 2009 because
28 EC would be the correct designation, would it, rather than 28 TFEU? Or?
Yes, it would, because the transactions challenged in this case occurred entirely during the period before the Lisbon renumbering and renaming came into force, and indeed almost 100% of the authorities relate to that period. So it seems convenient to continue with that numbering rather than giving your lordship a concordance with every citation. Now, in relation to goods, the primary source of law on the subject is Article 28 of the treaty, and in relation to services, it is Articles 43 and 49. Now, those articles impose obligations on public bodies in relation to procurement functions which operate quite independently of any directives on the subject. If your lordships would turn to a supplemental authorities bundle which I supplied shortly before your lordships came in, you will find the consolidation as it existed before December 2009. Article 28 is concerned with quantitative restrictions on imports and all measures having equivalent effect. Article 43 is the right of establishment, i.e. the right of nationals of any member state to set up in business in any other. And Article 49, which seems, I'm afraid, to have got accidentally omitted from this. I had intended to copy Articles 49 to 60. I'll make that good, if I may, later in the day. But Article 49 prohibits restrictions on the freedom of any business established in a member state to provide services. My lords, in addition to those 3 articles, the European Court of Justice, when applying Articles 43 and 49 in the context of procurement, has commonly taken into account Article 12, which is the general prohibition of discrimination on the grounds of nationality, and Article 14, which is the internal market article. Now, my lords, the treaty provisions apply directly because they are the provisions which confer the four so-called fundamental freedoms: freedom of movement of goods, services, people and capital. Articles 43 and 49 have been interpreted as directly imposing on public authorities, even in the absence of a relevant directive, certain obligations in the exercise of their procurement functions. The content of those obligations is normally summed up in the two principles of transparency and non-discrimination. The obligation of transparency, as it applies directly from the treaty, doesn't necessarily require a public authority to put contracts out to tender. But the least that public authorities must do to comply with Articles 43 and 49 of the treaty is to advertise the contract in a way that can reasonably be expected to reach all potential suppliers, and they must publicly identify the criteria for selection so that fairness in their processes can be externally established. They may have to do more than that in particular cases. The obligation of non-discrimination is to select the actual supplier on objectively justifiable grounds free of discrimination. The directives, where they apply, supplement the treaty provisions by laying down detailed rules applicable to certain categories of transaction, which lay down exactly when you have to go out to tender, what the tender documents have to say, what are legitimate criteria, and so on. They are much more detailed and prescriptive than the more general obligations arising directly from the treaty. Now, we will see references in the case law to earlier directives, and it may therefore assist if I were simply to tell your lordships how we got to the 2004 directive. The first directive on public procurement was issued in 1971, the year in which the transitional provisions of the original Treaty of Rome, which gave a lengthy period to member states to adapt their internal arrangements to the treaty, expired. The first directive of 1971 was concerned only with public works contracts. There was then a second directive in 1977 which applied to the procurement of goods. Services outside the field of public works were first covered by a directive in 1992, and that was the directive under which virtually all the cases that I shall be showing your lordships was decided. There is a separate regime for utilities, which was originally embodied in a directive of 1993. In 2004, all of these directives were replaced by two directives. There is, first of all, a directive covering works, goods and services other than those procured by utilities.
That's number 18, is it?
I'm sorry, my
Is
lord.
that number 18?
Yes. And there is a separate directive issued simultaneously which covers utilities. Now, the general 2004 directive, which is what your lordships are concerned with, did not just consolidate the three previous directives addressed to works, goods and services. It also expanded the scope of the transactions covered in certain respects. It refined the categories to which different detailed rules applied, and it elaborated the rules themselves. But in the respects which are relevant to the issues on the present appeal, the 2004 directive was in the same terms as the 1992 directive. Both the 1992 directive and the 2004 directive covered what were referred to as contracts for pecuniary interest, which the English regulations in our submission accurately translate as contracts for consideration. Of course, in English law, all contracts are contracts for consideration, but that is not true of Scottish law nor of civil law systems, which is why the reference to consideration in the directive is necessary. There are many procurement transactions to which neither the 1992 nor the 2004 directives applied, and these are transactions that continue to be governed directly by the treaty. And for an understanding of the case law, it's quite important to understand what they are. There are three main categories of transaction which are not covered by the directive, but are covered directly by the treaty. The first is transactions which fall below the value limits in the directive. There are value limits, different value limits dependent on different sorts of transaction in the directive, and below that the directive doesn't apply, but the treaty may do.
May do, but not universally.
No. Secondly, there are transactions which are not contractual at all, and they are not covered by the directives either. For example, where goods and services are supplied by a public sector body under a purely public law obligation, as they sometimes are in Spain and France, the relationship is not contractual, the directive therefore does not apply, but the treaty does. Thirdly, the category that features most prominently in the authorities, service concessions. This is the state of affairs where instead of contracting with a firm, for example, to manage the municipal car parks for a fee, you allow them to run it for their own account and charge drivers for parking. That is what is defined as a service concession in the current directive. It's a category which was held in a case called Tell Austria in 1998 to fall outside the scope of the 1992 directive, which was then in force. And the reasoning in that case is of some interest. If your lordships would take volume 7 of the bound authorities volumes, at flag 47, this was about a concession for the publication of national telephone directories in Austria, and it was the case that decided that a concession was not within the then directive of 1992. The reason, in summary, was not that they fell outside the definition as a matter of pure language of contracts for pecuniary interest. The reason was that a consideration of the travaux préparatoires showed that that service concessions had originally been included in the drafts, but were then, as a matter of decision in the course of the negotiation of the directive, taken out. And it was held that therefore they could not be treated as being covered. Now, having decided therefore for other reasons that service concessions were intended to be excluded, the court held that they could not be regarded as contracts for pecuniary interest. If your lordships look at paragraph 56 in the judgment, paragraphs 46 to 56, which I won't read, consist of a lengthy analysis of the travaux préparatoires and the negotiation history leading to the directive. And paragraph 56, by way of conclusion, in the second block of text under paragraph 56, since public service concession contracts do not therefore come within the scope of the directive, it must be concluded that contrary to the interpretation proposed by Tell Austria, such contracts are not included in the concept of contracts for pecuniary interest concluded in writing, appearing in Article 1.4 of that directive. Now, there's another purpose for which I want to show your lordships this case, which I'll come to in a moment, but this is actually typical of something that your lordships will see in other cases. You find the ECJ saying a particular kind of contract is not included in the term contracts for pecuniary interests, But that is not because of an analysis of the meaning of those words, contracts for pecuniary interest. It is, in some cases, because of something completely extraneous to the language, which must be taken as governing the language because of the principles of construction that are applied by the court. Now, the obligations which exist independently of the directive in a case to which the directive doesn't apply, and of course what was held is that the directive didn't apply in this case, have been the subject of a number of ECJ decisions, and in this particular case, if your lordships turn to paragraph 60 of the court's judgment, the existence of direct obligations derived from the treaty is recognised, as indeed it had been in earlier jurisprudence. In that regard, it should be borne in mind that notwithstanding the fact that, as community law stands at present, such contracts are excluded from Directive 93/38, the contracting entities concluding them are nonetheless bound to comply with the fundamental rules of the treaty in general and the principle of non-discrimination on the ground of nationality in particular. As the court held in Unitron Scandinavia, that principle implies, in particular, an obligation of transparency in order to enable the contracting authority to satisfy itself that the principle has been complied with. That obligation of transparency, which is imposed on the contracting authority, consists in ensuring, for the benefit of any potential tenderer, a degree of advertising sufficient to enable the services market to be opened up to competition and the impartiality of procurement procedures to be reviewed. Now, that point was expanded and rationalised in a later case, Konami, which your lordships will find in the supplementary authorities bundle at flag 2. Your lordships will find that in flag 2 of the supplemental authorities bundle. Now, this was about a service concession which was outside the scope of what was the then current directive, as your lordships will find in the judgment of the court at paragraph 9. It must be observed at the outset that the case in the main proceedings appears to relate as follows from the reply given by the referring court to a request for clarification to a service described as a concession which does not fall within the scope of either the 92 directive relating to the coordination of procedures for the award of public service contracts, or Council Directive 93/38, that was the one referred to in Tel Austria, coordinating the procurement procedures of entities operating in the water, energy, transport and telecommunications sector. See Tel Austria and Buchhandler Bereinigung. Then, if your lordships turn on to paragraph 16 of the court's judgment, there's a statement of principle about the direct application of the treaty. It must be remembered that the award of such a concession is not governed by any of the directives by which the community legislature has regulated the field of public contracts. In the absence of any such legislation, the consequences in community law of the award of such concessions must be examined in the light of primary law, and in particular of the fundamental freedoms provided for by the treaty. In that regard, it must be pointed out that insofar as the concession in question may also be of interest to an undertaking located in a member state other than the member state of the Comune di Cincingia di Botti, the award, in the absence of any transparency, of that concession to an undertaking located in the latter member state amounts to a difference of treatment to the detriment of the undertaking located in the other member state. In the absence of any transparency, the latter undertaking has no real opportunity of expressing its interest in obtaining that concession. Unless it is justified by objective circumstances, such a difference of treatment, which by excluding all undertakings located in another member state operates mainly to the detriment of the latter undertakings, amounts to indirect discrimination on the basis of nationality prohibited under Articles 43 and 49 EC, and they refer to Luxembourg and Eurowings Luftverkehr. Now, the General Directive of 2004 which I want now to come to, is the one that we are concerned with, and that, your lordships will find in the first of the bound authorities volumes at flag 2. Now this is a lengthy document, but I am only concerned with relatively small parts of it. Yes, flag 2. The legal base of the directive is identified in the ordinary way in the first paragraph before the recitals, having regard to the treaty, in particular 47.2, 55 and 95. Now, in the absence of a full copy of this part of the treaty at the moment, I will get it in due course. I will just tell your lordships what those are. I don't think it's controversial. 47.2 is the power to issue directives in relation to the right of establishment, which is conferred by Article 43. Article 55, which is the second article referred to, confers the same power to make directives in relation to the freedom to provide services conferred by Article 49. Article 95, which has, I think, been copied,
Yes.
is the power to issue directives for harmonisation. And if your lordships would turn to 94 and 95, the basic power to issue harmonisation directives is conferred by Article 94, which requires unanimity. Article 95 authorises the issue of directives by the procedure in Article 251, see subparagraph 1. 251 is the article which provides for decision by qualified majority. Article 95 relates to directives for achieving the objectives in Article 14, i.e. the internal market. So the effect of that is that there is a power to issue directives by qualified majority for the approximation of the laws of member states in areas relevant to achieving the internal market. In his printed case, my learned friend criticises the Court of Appeal for referring to the directive as a harmonisation measure. It is not only a harmonisation measure, but it is certainly that among other things. Now, your lordships should perhaps note the first two recitals that appear underneath that in the directive itself. Recital 1 records the purpose of the new directive in relation to previous directives. On the occasion of new amendments being made to the 92 directive relating to the coordination of procedures for the award of public service contracts, the directive of 93 for coordinating proceedings relating to public supply contracts, and the directive of 93 concerning the coordination of procedures for the award of public works contracts, which are necessary to meet requests for simplification and modernisation made by contracting authorities and economic operators alike in their responses to the Green Paper adopted by the Commission in 1996, the directives should, in the interests of clarity, be recast. This directive is based on Court of Justice case law, in particular case law on award criteria, which clarifies the possibilities for the contracting authorities to meet the needs of the public concerned, including in the environmental and social area, provided that such criteria are linked to the subject matter of the contract, do not confer an unrestricted freedom of choice on the contracting authority, are expressly mentioned and comply with the fundamental principles mentioned in Recital 2. We then have in Recital 2, the award of contracts concluded in the member states on behalf of the state, regional or local authorities and other bodies governed by public law entities is subject to the respect of the principles of the treaty, and in particular the principle of freedom of movement of goods, the principle of freedom of establishment, and the principle of freedom to provide services, and to the principles deriving therefrom, such as the principle of equal treatment, the principle of non-discrimination, the principle of mutual recognition, the principle of proportionality, and the principle of transparency. However, for public contracts above a certain value, it is advisable to draw up provisions of community coordination of national procedures for the award of such contracts, which are based on these principles so as to ensure the effects of them and to guarantee the opening up of public procurement to competition. These coordinating provisions should therefore be interpreted in accordance with both the aforementioned rules and principles and other rules of the treaty. Now, in the effect, therefore, is basically to consolidate the three previous categories of public works, service contracts, and public supply contracts, to recast the provisions in the interests of clarity, and to introduce a number of amendments to the detailed procedures. Now, Article 1 in the directive is the definition provision, and that defines public contracts, which is the category of contracts to which the directive applies. Article 1.2a.
Sorry, Article 1?
1.2a.
2a, yes.
Public contracts are contracts for pecuniary interest concluded in writing between one or more economic operators and one or more contracting authorities, and having as their object the execution of works, the supply of products, or the provision of services within the meaning of this directive. Now, contracts for pecuniary interest, that in our submission simply means contracts for a consideration in money or money's worth. And as we've seen in Tel Austria, it would have included service concessions but for the legislative history, which excluded that category by implication from the directive. Now, public contracts includes public service contracts, and they are listed in Annex 2. I needn't refer to that, but Annex 2 lists, among other contracts, financial contracts, including contracts relating to insurance.
Sorry, what have you just read?
My Lords, the public contracts include public service contracts, which is a term that your Lordship will find defined at 1.2d.
Yeah. And we see just opposite the opposite page.
Yes, contracts having as their object the provision of the services referred to in Annex 2.
Yeah.
And if your Lordships turn to Annex 2, which is at page
162. 162.
162. I'm grateful. Page 162.
Yes.
Your Lordships will find a category of financial transactions, including insurance.
Insurance services in 6.
Yes, it's category 6B on page 162.
6A.
6A, forgive me. My Lords, in the directive, Articles 1.3 and 1.4 define concessions. The relevant one is 1.4. A service concession is a contract of the same type as a public service contract, except for the fact that the consideration for the provision of the services consists either solely in the right to exploit the service or in this right together with a payment. Now, that is a category which was previously excluded from the scope of the earlier directive, not by a provision of this kind, but by judicial decision in Tel Austria. What the technique adopted in this case was to include a definition of service concessions, and then in Article 17 expressly to exclude those from the scope of the directive. Your Lordships turn to Article 17 on page 132. Service concessions without prejudice to the application of Article 3, which is concerned with special and exclusive rights. This directive shall not apply to service concessions as defined in Article 1.4. Now, I don't need to take your lordships to the provisions about public works concessions. They don't feature in the argument or the case law in the same way, but essentially public works concessions are subject to a more limited regime of regulation under Title 3 of this directive. But service concessions are excluded altogether, save for the provisions of Article 3. Article 2 of the directive contains the general principle: contracting authorities shall treat economic authorities, or operators, equally and non-discriminatorily, and shall act in a transparent way. Those are in fact exactly the same as the provisions of the treaty, clauses, Articles 43 and 49, as they've been interpreted. Now, the English regulations implementing that, together with the explanatory memorandum — I'm not going to take your lordships through the detailed rules because they don't have any bearing on the issue that your lordships have to decide. But if your lordships would take the second of the bound authorities bundles, you will find at 2 flag 11 the public contract regulations, and at flag 9 the explanatory memorandum. I wonder if we might start with the explanatory memorandum. Paragraph 2 is the general introductory paragraph. Both regulations covered by this memorandum implement new EU procurement directives and replace existing regulations in this area. The Public Contracts Regulations 2006 implement the new Public Sector Procurement Directive, which provides revised rules for the procurement of supplies, works and services above certain thresholds. And I don't think we need the rest of that paragraph. Paragraph 4, legislative background. These two regulations are being made to implement EU directives under Section 2.2 of the European Communities Act. They will replace existing regulations which cover similar ground. And then differences in the new regime are summarised over leaf at paragraphs 7.2 to 7.4. The change of the legislation is necessary to implement two new public procurement directives, one covering the public sector and the other covering utilities. The directive sets out the procedures to be followed at each stage of the procurement process. The new public sector directive brings in 3 previous directives on the public sector procurement, covering supplies, works and services into one text, and provides a more consistent set of rules for these 3 kinds of contracts. It also clarifies and modernises the previous texts to make the rules more helpful to today's procurers and suppliers. It introduces a new procedure called competitive dialogue for particularly complex projects. It also includes a provision for the first time on framework agreements. The new Utilities Directive updates the previous version, in particular on coverage, and it introduces an exclusion mechanism for activities which are fully exposed to competition and where market access is open. Both directives also cover electronic procurement systems, including e-auctions, for the first time, and provide some clarity of the scope to take account of environmental and social issues. The simpler and more consistent public sector text should reduce the burdens involved in procuring goods, works and services under EU rules, while the scope to make use of modern procurement methods and systems, such as EU auctions, framework agreements and competitive dialogue, should improve efficiency in public procurement and help deliver value for money for the taxpayer. Then, if your lordships look at paragraph 4.2, there's a list of the various options. The options for implementation are constrained by the requirements of the directive, which has already been adopted at European level. Within these constraints,
I'm lost.
I'm sorry, my lord, it's paragraph 4.2. It's 3 pages beyond the part I've just read. Sorry.
Oh, yes, sorry.
Right. Yes, sorry. The paragraph numbering restarts
Yes.
on the third
Yes, I got
page
it.
when it comes on to regulatory impact.
Yes, thank you.
Forgive me, I should have mentioned
Yes.
that.
Yes.
Under that heading, your Lordships should perhaps first note at paragraph 2.4 under regulatory impact. The directive reenacts most of the provisions of the existing directives while simplifying, clarifying and modernising them. It will benefit public sector bodies awarding contracts by improving efficiency and effectiveness and by allowing them to take advantage of modern procurement techniques. Points of clarification will provide greater legal certainty. Even if the European directives did not exist, UK policy and the EU treaty would require contracting authorities to follow similar rules, such as the obligations to advertise, because they ensure value for money and transparency. The consolidation of directives and clarification of certain points in the new directive should lead to an increase of efficiency in this area. Then 4.2, 2 pages further on, lists the options open to the United Kingdom. Within these constraints, there are a number of articles in the directive where member states had choices as to how, and in some cases whether, to implement particular provisions, and they refer to those. And I think one can then turn to the text of the regulations themselves, which is behind tab 11.
Are we concerned with any of the things listed in 4.2?
No, your Lordships are not concerned with those, though there is an argument which will involve not looking at the details of those, but at the concept of optional methods of implementing a directive.
See.
My Lords, behind tab 11, the text of the regulations in our submission are an accurate transposition of the text of the directive into English law, with the minimum of adaptation which is necessary in order to fit in with the principles and terminology of the English law of contract. The only substantive change, which has no bearing on the issues on this appeal, is that the regulations have incorporated one change which arose from a judicial decision of the ECJ that came too late to be incorporated in the text of the directive. That was a pair of decisions, your Lordships I don't think need to be concerned with the detail, arising out of a case called Alcatel and another one called Commission in Austria, in which the ECJ had required a period of delay between the award of a contract and its implementation in order to allow objectors to the tender process to obtain relief from the courts. And that was something that is the one substantive respect in which the regulations differ from the directive. The regulations, as the first line record, are made by the Treasury under Section 2.2 of the European Communities Act of 1972. Regulation 2.1 contains the definitions, and your Lordships are concerned with the definition that appears on page 4 of 96 in the printout. Public contract means a public services contract, a public supply contract, or a public works contract. And a public services contract, which is what we're concerned with, means a contract in writing for consideration, whatever the nature of the consideration, under which a contracting authority engages a person to provide services, but does not include a public works contract or a public supply contract. But a contract for both goods and services shall be considered to be a public services contract if the value of the consideration attributable to those services exceeds that of the goods covered by the contract, and a contract for services which includes activities specified in Schedule 2 that are only incidental to the principal object of the contract shall be considered to be a public services contract. The essential part of that definition for your Lordship's purposes is the first two lines. Now, a contract for pecuniary interest in our submission accurately transposes the expression, is accurately transposed by the expression contract for consideration. Now, Regulation 5.1, your Lordship would turn on to that, application, subject to paragraphs 1a and 3, these regulations apply whenever a contracting authority seeks offers in relation to a proposed public supply contract, public works contract, Part A services contract, framework agreement or dynamic purchasing system, other than a contract framework agreement or dynamic purchasing system excluded from the application of these regulations by Regulation 6 or 8. And the only exclusion that your lordships are concerned with is the one that appears at Regulation 6 2M on page 11 of 96. It's the last of the exclusions under Regulation 6, which excludes services concessions awarded by a contracting authority subject to the application of Regulation 46. And Regulation 46 is the equivalent of Article 3 of the directive, and in other words, the drafting technique that has been applied is that they have used a general expression to define the relevant contracts because, as a matter of English law, a concession, a services concession, would be a contract for consideration, or could be a contract for consideration. They have deliberately excluded it in order to give effect to the principle in Tel Austria. Now, the details of the rest of the regulation...
Sorry, I mean, is it to give effect to that or to give effect to the new definition in the directive?
Well, clearly on its own, the definition gives direct effect to the definition of the directive. The directive's definition has not changed between 1992 and 2004, and neither have the English law definition changed. But because the European Court in Tel Austria ruled that for reasons unconnected with the choice of the phrase contract for pecuniary interest, it was necessary to exclude services contract. That has been achieved in the English transposing regulation by an exclusion from a category that would otherwise cover it. If you didn't have exclusion 6M, then an English lawyer might say that because a services concession was in most cases a contract for consideration, it was covered, and therefore effect would not be given to the Tel Austria decision if that had been done.
Is this mentioned in the explanatory memorandum, or do we just...
My Lord, it is not.
We just take it as...
But when one reads Tel Austria and the regulation, it is clear that that's what they're doing.
Right.
And indeed, as your lordships will recall, the directive itself has an exclusion of services concessions from the scope of the directive. One can argue that in the directive it wouldn't have been necessary because of the way that the ECJ has interpreted the expression, but it's clearly necessary in the English regulations. Now, my lords, those are the legislative materials. I want to come now to the materials on the TECAL exception. The TECAL exception is a limitation on the scope of the European public procurement regime, which was first formulated by the court in 1999 in TECAL against Comune di Viano. The effect of the exception is to exclude from the scope of the public procurement regime what have been called quasi-in-house procurement transactions. It's a very inelegant term, but it's descriptive and it appears in quite a lot of the cases. The reasoning underlying the exception is that it is no part of the purpose of the European procurement regime to require public authorities to go out into the market for their procurement if they wish to procure goods and services from their own resources. Local authorities or public authorities generally are entitled to do it themselves without giving the opportunity to supply to external contractors if they wish to. Now that gives rise to no particular difficulty in a case where a public authority uses, for example, its own direct labour force to maintain buildings or collect the rubbish. There is absolutely no obligation under the EU procurement regime to open up those activities to outside competition.
It wouldn't normally be a contract at all, would there?
Well, it wouldn't normally be a contract at all. Now, the difficulty arises in a case when there is a contract because you use a vehicle company, either a consortium company or a wholly owned company. And these are the so-called quasi-in-house procurement arrangements, where a public authority procures goods or services from an entity which is a juridically distinct entity, so that you can have a contract, indeed normally would, but an entity which it controls, for example, a corporate subsidiary. Now, the commonest reason for setting up a corporate subsidiary for a public authority has been to use it as a vehicle for the collective procurement of goods or services by a group of public authorities. And most of the litigation on this subject in the European Court of Justice has occurred in that context.
So if there was no group and there was just simply a direct descent from the public authority to the corporate subsidiary, wholly owned,
it would still be a quasi-in-house contract,
yes,
because there would, on that hypothesis, be a distinct legal entity with which you would normally, the authority would normally have a contract. And in fact, there are, both in Europe and in the United Kingdom, a number of reasons why local authorities in particular may wish to use corporate subsidiaries. To take just one example, which happens to be relevant in this case because it's a category dealt with in the LAML rules, local authorities very commonly use corporate entities to manage all or part of their housing stock in order to be, because it's a convenient vehicle with which to involve other interests such as tenants. But there are actually very many occasions why, even without a consortium, a public authority may wish to use an incorporated body to carry out part of its services, and it will commonly do so under a contract when it creates such a body. Now, the principle in TECAL applies in accordance with the decision in TECAL itself, where two conditions are satisfied. First, the public authority must exercise over the supplier a control similar to that which would be exercised over a department of itself. And that is what, in our printed case, we have referred to as the control test. The second condition, which we refer to as the function test, is that the essential part of the supplier's business must consist in supplying the public authority or authorities which control it. Now, as your lordships will see, where the supplier is controlled by a consortium of public authorities, the control test is satisfied by the existence of collective control, even if no individual member of the consortium could control the entity on its own. That is not accepted by my learned friend, but I shall submit to your lordships by reference to the authorities that it is what they say.
So you're saying collective control, provided the essential element of is present in it,
Yes.
will do.
Yes. And that this issue has been directly confronted by the European Court of Justice on a number of occasions, particularly in a case called Coditel, but I'll come to that. And of course, what it means is that the individual contractor, the contracting local authority being part of the consortium, may have no ability to control the supplier on its own. The only ability that it has to control the supplier arises from the possibility of cooperation with other members of the consortium. But where the members of the consortium as a whole have collective control over the body, that will, on the authorities, satisfy the control test.
Mr. Thompson, your function test you describe as the contractor's essential function must be to supply.
Yes.
But then you go on to say shouldn't have other customers as well. So, I mean, is it the contractor's exclusive function must be to supply the controlling
No.
authority.
An essential function is the expression used in TECAL itself, which is why I have used it.
But can they supply others as well?
Yes, they can do so if the supply to others is marginal to its activities. It's a question of degree, which has never been precisely defined, but the existence of a not significant business with other parties will not prejudice the application of the function
So
test.
when you say you shouldn't have other customers, you shouldn't have many other customers.
Well, that's what it amounts to. Your Lordship no doubt would regard that as a very imprecise criterion, and I agree. But I'm afraid that is a problem that one has with many European community principles.
Well, many may not encapsulate it because there may be a few, but they may be very important.
Exactly. I mean, it's a qualitative approach. Nobody has suggested, certainly I'm not suggesting, that it's simply a head count of customers.
And are we going to grapple with that in issue
No.
5?
Fortunately, your Lordships do not have to grapple with that because LALM was a company which, under its memorandum, could only insure London local authorities. There is a subsidiary power which is more extensive, but it is only subordinate to the main power and is therefore, it wouldn't give rise to a right to conduct an independent insurance business. I'm going to take your Lordships to that material in due course. My Lords, there are perhaps 2 points that should be made at the outset about the TECAL exception and the case law on it before we actually turn to those cases. The first is that the exception applies when the 2 conditions are satisfied to all public procurement, whether it is governed by the directive or directly by the treaty.
No, that's going to be clear from TECAL itself, or is it in
No,
principle?
it will not be clear from TECAL itself, which was a directive case, but it will be clear from a number of cases, including in particular a case called Asemfo, which was about Spanish agricultural institutions, and Codital. What your Lordships will see in the cases is that the European Court has applied exactly the same TECAL principles, both to cases governed by the directive and to cases where the directive doesn't apply, usually because it's a service concession, but the treaty does. Now, in that respect, this is an exception which differs from other judicial exclusions, such as service concessions, which are exclusions only from the scope of the directive and leave the corresponding obligations derived from the treaty itself intact. So this is a much more fundamental limitation of the EU procurement regime as a whole, applicable irrespective of whether the directive applies or it's just the treaty.
And you say, I take it, that helps us to understand that it applies in this case.
Indeed it does, but it's important for a number of reasons, but in particular, what it shows is that although the exception is a judicial gloss on the relevant legal instruments, it can't be treated as a special interpretation of any particular words or phrases in the directive. It may follow from the interpretation that contracts for pecuniary interest do not include TECAL cases, but the actual process by which that conclusion is arrived at is not dependent on an analysis of the meaning of that phrase. It is dependent on an altogether more fundamental approach to the purposes of the procurement regime. Now, the TECAL exception is not stated in terms, either in the relevant provisions of the treaty or in the successive directives. It is a purely judicial gloss on both sources of law. Now, the second initial observation which is called for is that, like all exceptions and derogations from a prima facie rule in European law, the TECAL exception has got to be restrictively applied. However, having said that, it is an exception which has undergone significant development since it was first formulated in 1999, generally in the direction of widening the test. And the test, albeit strictly applied, is unquestionably a wider test in the light of the subsequent developments than it was at the outset. There is a very large number of ECJ decisions about the application of the TECAL exception, more than 40 on my count, and I doubt whether that's complete. Your Lordships will be relieved to hear, however, that in the rather robotic fashion of judgments of the European Court, most of them simply repeat verbatim the formula used and then tell the national courts to go away and work out how it applies to the facts. There is, however, a small number of milestone cases which show what the European Court means by the original formula.
And just to see where we're going with this assumption, is just Mr. Howell largely in agreement with you as to what these milestone cases are, or are we going to have ourselves spread out over a wider range?
We both refer to the same cases. My learned friend Mr. Howell refers to many other cases which, as it seems to us, have absolutely nothing to do with the issue. I'm not going to take your Lordship's time up by citing cases which I submit have nothing to do with it. But I will respond to those in reply. Obviously, if there are cases which qualify what I am saying in some significant respect, I will regard myself as obliged to show that to your Lordships in the course of my submissions. But it doesn't seem economical for me to anticipate absolutely everything that my learned friend will be saying. I think it's common ground that the cases which I am citing are, at any rate, the major cases. Now, what they disclose is a growing emphasis on the underlying rationale of the exception, which is that public authorities ought to be allowed to procure goods and services from separate entities without having to comply with the procurement regime if, although those entities are set up as companies, as they usually are, they are wholly identified with the performance of the public functions of the authorities which control them and have no wider commercial objectives. Now, TECAL itself, your Lordships will find in Volume 7 of the Bound Volumes of Authorities. At tab 46. The facts, in very brief summary, were that the case concerned a consortium of 45 Italian communes who created a collectively controlled vehicle called AGAC to carry out mainly building maintenance and improvement. The commune of Viano, which was the defendant in these proceedings, and had entered into the relevant contract with AGAC, held less than 1% of the shares of the vehicle company. Now, there was an issue in this case, which doesn't matter for present purposes, about which directive applied to the transaction. There was no doubt, however, that one of them did. It wasn't, therefore, a case where the treaty applied directly. If your Lordships would turn to the judgment, at paragraph 41, the Court observes, under the heading Substance, in order to determine whether the fact that a local authority entrusts the supply of products to a consortium in which it has a holding must give rise to a tendering procedure as described under Directive 93/36, it is necessary to consider whether the assignment of that task constitutes a public supply contract. And then, after a discussion of the general features of the directive, I think one can pick up the reasoning on the relevant point at paragraph 49. As to whether there is a contract, the National Court must determine whether there has been an agreement between two separate persons. In that regard, in accordance with Article 1A of the directive, it is in principle sufficient if the contract was concluded between, on the one hand, a local authority and on the other, a person legally distinct from that authority. The position can be otherwise only in the case where the local authority exercises over the person concerned a control which is similar to that which it exercises over its own departments, and at the same time that person carries out the essential part of its activities with the controlling local authority or authorities. Now that is the TECAL test stated in the formula that your lordships will see repeated in many subsequent cases.
Yes.
And the main reason why we don't accept that all the additional cases referred to by my learned friend assist is simply that in many of those cases the court has done nothing more than repeat that formula and apply it to particular facts. That isn't true in all cases, but it's true in a very large number of them. Now, that therefore is the TECAL principle as expressed. The court is saying that clearly contract is a matter of national law. The court is saying, however, that the national courts have got to determine whether there's been an agreement between two separate juridical persons. In the normal run of cases, that will be enough to engage the terms of the directive. But, they say, as a matter of European law, and the question what characteristics an agreement must have in order to fall within the procurement regime is a question of European law. As a matter of European law, what they are saying in paragraph 50 is that even in a case where you have an agreement between two legally juridically distinct persons, and where therefore there is undoubtedly a contract as a matter of national law, nevertheless, the procurement regime will not apply in a case where the two conditions stated at the end of paragraph 50 are satisfied. That is, so to speak, a European overrider on the national law of contract. Now, it is implicit. The court didn't actually decide in this case.
Of course, if you mind, just to see where this is derived from. I mean,
where the TECAL exception is derived from.
It's derived from the directive.
Well, in this case, it's derived from the directive, yes, because this was a case where the directive, one of two directives in materially the same terms, as far as this issue was concerned, undoubtedly applied. So this is not a case which has any authority for the operation of the TECAL exception outside the framework of the directive. Now, it is of some interest, although the answer to the case in question was not provided by the court. They referred the application of that test to the facts back to the Italian courts. It is clearly implicit in that that collective control might be enough, because the Comune di Viano, with a tiny proportion of the shares of AGAC, could not reasonably be said to have control on its own. But that was not an issue which was actually considered by the court in that case. Now, the first significant case to expand and explain the TECAL test was Stadt-Halle, which is to be found in the same bundle at flag 45. Now, this was not a consortium case. This was a case about a contract for the treatment of waste by the municipality of Halle, which the municipality made with a company in which it held 75% of the shares. The other 25% were held by private commercial interests. Now, manifestly, as a matter of company law, 75% is enough to give the municipality control over the company, so far as any shareholding could. But the control test wasn't satisfied in this case, for a reason that discloses for the first time the developing interest of the European Court in the public interest aspects of this issue. What was held in Stadt-Halle was that the participation of private capital, even on a minority basis, was inconsistent with the exception applying. Now, that was the first step which the European Court took after TECAL towards the notion that the main function of the control test is to determine how far the supplier is identified with the public functions of the authority. Any amount of control, in a company law sense, will be insufficient if there is significant private capital involved, because that, according to the court, is not consistent with the total identification of the supplier with the public objectives of the authority. Now, the way that I've just put it is my gloss on much more clipped statement, which your lordships will see, but it is fully justified as a gloss by the later authorities. Now, it's worth starting with the opinion of the Advocate General Stix Hakel, who, as is common, sets out the legal background rather more fully than the court itself. At paragraph 49 of her opinion, under the heading Quasi-In-House Procurement, she says, the second set of questions concerns the conditions attaching to quasi-in-house procurement, as it has been termed. This, as the Austrian government has correctly stressed, differs from in-house procurement, self-supply, in that it involves awards to an entity separate from the contracting authority and having legal personality. If the entity responsible for the supply lacks legal personality, no contract could exist. One of the preconditions for a contract, within the meaning of the procurement directives, would then be missing. What is strictly at issue in the present case is the interpretation of the concept of contract, the existence of which is a precondition for the application of the procurement directives. The starting point must be tekal. The court held there that certain stages in the procurement process are not covered by the procurement directives. Then if one turns on to paragraph 58 of the Advocate General's opinion to pick up the reasoning that's relevant for our purposes, paragraph 58, in general, it is necessary to distinguish between three different quasi-in-house scenarios. Awards to wholly owned companies owned 100% by the contracting authority or entities which may be equated with that authority. Awards to joint public companies whose shares are held by a number of contracting authorities, and awards to semi-public companies in which genuinely private parties hold a stake. And Stadthaler itself was in that last category. Then at 62, under the heading First Criterion, control similar to that which it exercises over its own departments, the first condition which must be met for the exception to apply, and accordingly for the procurement directives not to apply, concerns the nature of the control exercised by the contracting authority over the body to whom the contract is to be awarded. The court requires that such control should be similar to that which they, the authority, exercises over its own departments. The court thus proceeds from a criterion taken from public law. However, as the concept of control, like that of contract and contracting authority, must be understood in functional, not formal terms, there is nothing to prevent it being applied to the relationship between a contracting authority and legal persons governed by private law, such as in the present case a limited liability company. The use of the term department derives from the original reason for setting up autonomous bodies, which was to move particular departments out of house. The fact that in the Tekal judgment, in the language of the case, Italian, the court requires only control which is analogous, analogo, that is comparable but not identical, provides further support for the view that the criterion in question may indeed be applied to other sets of circumstances. And moving on then from there, that I think is as much as one gets of value by way of background from the Advocate General's opinion in this case. The Advocate General goes on to say that the 25% private shareholding was no problem because the 75% shareholding was bound to be dominant. And that is the point on which the court disagreed with her, which is why I'm not going to take your lordships to that part of her opinion. And they disagreed with her on that point because the existence of the 25% private shareholding, although it was not enough to carry votes at general meetings, was enough to ensure that the directors would have to have regard to interests other than the public interest served by the authority. Now, if your lordships would turn to the judgment of the court, I think one can start at paragraph 42. Yes, under the heading Questions 2A and B. By this second set of questions, which should be considered together, the National Court essentially asks whether, where a contracting authority intends to conclude with a company governed by private law, legally distinct from the authority and in which it has a majority capital holding and exercises a certain control, a contract for pecuniary interest relating to services within the material scope of the directive, it is always obliged to apply the public award procedures laid down by that directive, merely because a private company has a holding, even a minority one, in the capital of the company with which it concludes the contract. If that question is answered in the negative, the National Court asks what the criteria are by reference to which it should be considered that the contracting authority is not subject to such an obligation. This question concerns the particular situation of a semi-public company set up and functioning in accordance with the rules of private law from the point of view of the obligation of a contracting authority to apply the community rules in the field of public procurement where the conditions for such application are satisfied. On this point, the principal objective of the community rules in the field of public procurement, as stated in connection with the answer to question 1, should be recalled, namely the free movement of services and the opening up to undistorted competition in all member states. That involves an obligation on all contracting authorities to apply the relevant community rules where the conditions for such application are satisfied. And moving across the page to paragraph 47, in the spirit of opening up public contracts to the widest possible competition, as the community rules intend, the Court has held, with reference to Council Directive 9336, coordinating procedures for the award of public supply contracts, that the directive is applicable in the case where the contracting authority plans to conclude a contract for pecuniary interest with an entity which is legally distinct from it, whether or not that entity is itself a contracting authority. It is relevant to note that the other contracting party in that case was a consortium consisting of several contracting authorities, of which the contracting authority in question was also a member. A public authority, which is a contracting authority, has the possibility of performing the tasks conferred upon it in the public interest by using its own administrative, technical and other resources without being obliged to call on outside entities not forming part of its own departments. In such a case, there can be no question of a contract for pecuniary interest concluded with an entity legally distinct from the contracting authority. There is therefore no need to apply the community rules in the field of public procurement. In accordance with the Court's case law, it is not excluded that there may be other circumstances in which a call for tenders is not mandatory, even though the other contracting party is an entity legally distinct from the contracting authority. That is the case where the public authority, which is a contracting authority, exercises over the separate entity concerned a control which is similar to that which it exercises over its own departments, and that entity carries out the essential part of its activities with the controlling public authority or authorities. It should be noted that in the case cited, the distinct entity was wholly owned by public authorities. By contrast, the participation, even as a minority, of a private undertaking in the capital of a company, in which the contracting authority in question is also a participant, excludes in any event the possibility of that contracting authority exercising over that company a control similar to that which it exercises over its own departments. In this respect, it must be observed, first, that the relationship between a public authority, which is a contracting authority, and its own departments is governed by considerations and requirements proper to the pursuit of objectives in the public interest. Any private capital investment in an undertaking, on the other hand, follows considerations proper to private interests and pursues objectives of a different kind. Secondly, the award of a public contract to a semi-public company without calling for tenders would interfere with the objective of free and undistorted competition and the principle of equal treatment of persons concerned, in particular in that such a procedure would offer a private undertaking with a capital presence in that undertaking an advantage over its competitors. Now, what is perhaps of particular interest of those two reasons is the first, the one stated at paragraph 50, because what the Court is saying there, in substance, is that the presence of private capital even on a scale which does not enable you to control the company as a matter of company law.
Yes, the word any is very wide embracing, isn't it?
Yes, but this is an absolute rule,
Yeah.
and the reason for it is that the presence of any private capital dilutes the concern of the entity with the public interest in a manner which is actually inconsistent with the underlying rationale of this case. The reason why you have a control test in our submission is primarily that you have to be satisfied that by delegating certain functions or transferring certain functions to a controlled entity, you are still ensuring that the functions are being exercised entirely in the public interest, that is to say, pursuant to the public functions of the contracting authority. If you have a semi-public company with a private capital element, the company will be bound to take account of wider interests, some of which will not necessarily relate to the public interest in the exercise of public functions. And that is a theme which first appears in this case, in which one can see more prominently developed in later cases.
Do we get any help from the way the first two lines of paragraph 48 are expressed? Is that...
Yes, I think Your Lordship probably
it does
do. A public
actually
authority,
contain the
which is a
phrase in the
contracting
public interest.
authority, yes. Because what he's saying is you start out with wholly in-house procurement. That is characterised by a situation in which the performance of the public functions of the authorities is the only relevant consideration. If you move from there to the use of a corporate vehicle, that's fine so long as you don't dilute the public service element.
That particular phrase didn't appear in TECL paragraph 50.
No, it did not.
I think.
You could not. The TECL paragraph 50 is simply a four-square block pronouncement with no elaboration, and the elaboration follows in subsequent cases, of which this is the first one of significance. Paragraph 52, which is the conclusion, is the answer to questions 2a and b must therefore be that where a contracting authority intends to conclude a contract for pecuniary interest relating to services within the material scope of the directive with a company legally distinct from it, in whose capital it has a holding, together with one or more private undertakings, the public award procedures laid down by that directive must always be applied.
So they answer the first bit of 42 in the positive, not the negative. 42, the first 7 lines ask the question. If that question is asked in the negative, but then it isn't, it's answered in the positive.
I'll just remind myself of 42, if you give me a moment. Yes, that is right. So the further questions didn't arise. The criteria didn't matter because in all cases the involvement of private capital was inconsistent with the control test. Now, the next case in this line is a case called Parking Brixton, which your lordships will find in volume 6 of the Bound Authorities volumes. And this is the first case that we come to, which involved a concession, i.e. a transaction outside the scope of the directives and governed wholly by the treaty. Brixton is a town in the German-speaking Italian Tyrol, a fact which it is necessary to mention because your lordships might otherwise think from the use of all the German expressions that appear that we were concerned with a German municipality. The town granted a concession to a wholly owned...
Which is it?
Sorry,
40, is it?
It's at flag 40, yes. The town granted a concession to a wholly owned limited company to run the car parks of the municipality in return for a right to charge motorists, so a classic service concession. Now, it was therefore not governed by the directive. Now, the case is interesting for 3 reasons. First of all, it contains a slightly fuller statement of the control test than TECL does, emphasising the need for what was called decisive influence over strategic objectives and significant decisions, rather than necessarily control over day-to-day activities. The second reason why it is interesting is that it applied the TECAL test for the first time to a transaction to which the directive did not apply. And the third is that although compliance with the control test had to be assessed at the time of the relevant transaction, if at that time it was already clear that prospectively private interests would be involved, then the Stat-Haller principle would apply and the TECAL conditions could not be satisfied. So it applied this to a prospective involvement of private interests as well as an actual one. They weren't saying the mere possibility was good enough, but where that development was written into the current situation.
And is that of interest to us because of the relationship between the participating members?
It's not a feature of the participating members here, but it is of interest because it explains some of the statements in the... There are suggestions that... I accept that if there is a real likelihood of developments inconsistent with the application of the control or the function test as at the time of the transaction, the fact that those developments have not yet occurred will not enable me to invoke the exception.
Yes.
Now, in this case, it is once again worth looking at the opinion of the Advocate General, Advocate General Kokot. Sorry, tab 40. I seem to have miscopied. Sorry. Because she, again, lays out the mental furniture for this area of law in a way that is, I would suggest, instructive. Not all of Advocate Kokot, the Advocate General's opinion was adopted by the court, but the basic analysis of the framework of procurement law is a perfectly fair summary of the authorities to date. Now, at paragraph 32 of her opinion, she notes that the transaction is not governed by the directive. For your Lordship's purposes, it's enough to look at the last sentence of paragraph 32. Does not constitute a public service contract within the meaning of Directive 9250, but a service concession not falling within the scope of that directive.
Did you say paragraph 32?
32 of the Advocate General,
Yes.
very end of that paragraph.
33.
I think it was 33.
I do apologise,
Yes,
it's 33,
yes,
forgive me.
thank you. Thank you.
Then at 34, the Advocate General deals with the procurement rules under the treaty, having decided that the treaty is the only source of law on this. By its second question, the referring court essentially wishes to ascertain the conditions under which a contracting authority may award to one of its subsidiaries, without first conducting an award procedure, a service concession, such as the authority to manage public pay car parks at issue in the main proceedings. Then there's a heading, Prohibition of Discrimination under Community Law, and the obligation of transparency even outside the scope of the procurement directives. 35, contrary to the view taken by the Netherlands government, it is already settled case law that contracting authorities are subject, even outside the prevailing scope of the procurement directives, to the requirement of community law arising from the fundamental rules of the treaty, in particular the fundamental freedoms and the prohibition of discrimination contained in them. The prohibition of, perhaps your Lordships should just cast an eye down at the footnote, 24
Yes.
and 25 for that.
Yeah.
24, in circumstances such as those of this case, the freedom to provide services, Article 49, and insofar as a foreign tenderer proposes to become established in Italy in order to manage the car parks, the freedom of establishment, Article 43, may be relevant. And footnote 25, see to this effect, in particular, Tel Austria, and two other cases. The prohibition of discrimination carries with it an obligation of transparency. Only if the award of a contract or a concession is carried out transparently can it be established at all whether in a particular case the principle of non-discrimination was observed or whether the decision to accept or reject a particular applicant was arbitrary. All of this does not mean, of course, that the procedure applied must be the same in every detail as that provided for in the procurement directives. However, as this court held in the judgment of Telaustria and Telefonadres, the obligation of transparency imposed on the contracting authority means that it must, for the benefit of any potential tenderer, ensure a degree of advertising sufficient to enable the services market to be opened up to competition and the impartiality of procurement procedures to be reviewed. Now, the procurement rules, she then points out, have to be applied in practice to all transactions, not just cross-border transactions. This is the point she makes at paragraph 39. It must be pointed out in this regard that it is true that the fundamental freedoms are not in fact applicable to purely internal situations. However, as the Commission, Parking Brixen and the Austrian government have rightly submitted, in public procurement law, any failure to fulfil the obligation of transparency has an impact not only on domestic undertakings such as Parking Brixen, but on all potential candidates, including any tenderers from other member states. Consequently, any lack of publicity always simultaneously affects the fundamental freedoms of potential candidates from other member states. Now, there is then a further heading, possible exception for operations with a contracting authority's own subsidiaries, the rule in TECAL. And under that heading, she says this: it remains to be considered, however, whether a contracting authority may exceptionally be exempt from the rules of community law described above in cases where it commissions services from entities which it itself controls. If the intention of the contracting authority in doing so is to use an organisationally independent public undertaking, in particular one of its subsidiaries, the answer appears initially to be readily apparent. In accordance with the principle of equal treatment of public and private undertakings, public undertakings must not, subject to the exceptions contained in Article 86, be treated more favourably than private competitors. A contracting authority cannot therefore simply entrust the provision of services to an undertaking which it controls without first giving any consideration to other possible tenderers or conducting a transparent selection procedure. On the other hand, the public body is of course at liberty to perform the tasks conferred on it by using its own resources, that's to say, by performing them in-house without calling on legally independent public or private undertakings at all. In those circumstances, moreover, it's not subject to the requirements of procurement law or Article 86 of the EC Treaty. As I said at the outset, the distinction between in-house operations and external procurement transactions not infrequently creates difficulties in individual cases. In its judgment in TECAL, the Court, in connection with Directive 93/36, established a precedent in this regard. It can be inferred from that judgment that procurement law becomes applicable in principle upon the conclusion of an agreement between two separate persons, in other words, upon the coming into being of a contract. However, the question whether or not procurement law is applicable depends not only on purely formal criteria, but also on a process of evaluation. For even where both parties to a legal transaction, from a formal point of view, each have their own legal personality, the transaction carried out between them may nonetheless exceptionally be treated in the same way as an in-house operation, insofar as the two cumulative criteria developed by the Court in its case law are fulfilled. And they summarise with two tests in TECAL. And continuing at paragraph 46, the TECAL criteria can also be transposed to circumstances such as those of this case, which do not fall within the scope of any of the public procurement directives. If the procurement directives, which lay down detailed requirements relating to the procedure for awarding contracts, themselves permit exceptions for in-house operations, such exceptions must, with all the more reason, be also permissible in cases where the procedural requirements are less detailed to begin with, relating only to the general conditions arising from the prohibition on discrimination and the obligation of transparency. The absurd consequence, if that were not the case, would be that in circumstances falling outside the scope of the directives, contracting authorities would be subject to stricter requirements than in circumstances falling within the scope of the directives. That is to say, that they would in that event have an obligation, without exception, to ensure transparency and publicity. Moreover, it must be taken into account that the procurement directives are for their part intended only to implement the fundamental rules of the EC as the treaty as they arise in the particular from the fundamental freedoms. Derogations from the directives are therefore ultimately derogations from those principles. This too supports the proposition that the rule in TECAL should be transposed to cases in which the prohibition on discrimination and the obligation of transparency derive directly from the fundamental freedoms without first having been given expression in the procurement directives. And finally, in the Advocate General's opinion, at paragraph 53, she has an observation about stat Haller, the mere presence of a private third party, even if only in the form of a minority holding without rights of veto, make it impossible for the contracting authority to exercise a control similar to that which it exercises over its own departments. And she gives the reasons for this. The reason for this is that the presence of a private third party always presupposes a minimum degree of consideration on the part of the public body for the private party's economic interests, for only then will a private third party make its know-how or financial might available to the public body in the first place. Thus, where a private third party, following the completion of a public call for tenders, where there has been one, acquires a holding in an undertaking, the consideration for the private party's economic interests may prevent the public body from fully pursuing its public interests, however legitimate such consideration may be from a purely legal point of view. It is essentially this combination of public and private interests which distinguishes semi-public undertakings, as they are known, from mere departments of the administration. And our submission, that is a fair analysis of what was said in Stat Haller. Now, she then goes on to make some observations about the implications of not allowing the TECAL exception. Paragraph 70. If, on the other hand, the procurement rules were also applied to transactions between contracting authorities and their wholly owned subsidiaries, the private law form of organisation of a public or private limited company could no longer be used purely for the purposes of internal reorganisation. In those circumstances, the public body in question would essentially be left with a choice between privatising its tasks or having them performed in-house by departments of the administration, or by dedicated undertakings which form part of the administrative hierarchy and have no real independence to speak of. In some cases, public bodies might even take the retrograde step of converting existing subsidiaries back into dedicated undertakings. However, such extensive interference with the organisational sovereignty of member states, and in particular in the self-government of many municipalities, is, even from the point of view of a market-opening function of procurement law, entirely unnecessary. After all, the purpose of the procurement law is to ensure that contractors are selected in a transparent and non-discriminatory manner in all cases where a public body has decided to use third parties to perform certain tasks. However, the spirit and purpose of procurement law is not also to bring about, through the back door, the privatisation of those public tasks which the public body would like to continue to perform by using its own resources. This would require a specific liberalisation measure on the part of the legislature. Now, my lords, after this point, the Advocate General goes on to deal with the application of the test in terms which were not adopted by the court, and so I won't refer to that part of it. Now, turning to the judgment, this judgment is important as the first unequivocal recognition that the TECAL exception is not concerned with some special meaning of the phrase contract for pecuniary interest in the directive, but is based on a more fundamental limitation on the scope of the European procurement regime in the public interest. Paragraph 43 of the court's judgment, the court makes the point that they are concerned with a service concession and therefore a transaction outside the directive. The reply, therefore, to the first question must be that the award by a public authority to a service provider of the management of a public pay car park in consideration for which that provider is remunerated by sums paid by third parties for the use of that car park, is a public service concession to which the directive does not apply. Now, the court then goes on at paragraphs 46 and following to deal with the direct application of the treaty. Notwithstanding the fact that public service concession contracts are, as community law stands at present, excluded from the scope of the directive, the public authorities concluding them are nonetheless bound to comply with the fundamental rules of the treaty in general and the principle of non-discrimination on the ground of nationality in particular. The prohibition on any discrimination on grounds of nationality is set out in Article 12. The provisions of the treaty, which are more specifically applicable to public service concessions, include in particular Article 43, the first paragraph of which states that restrictions on the freedom of establishment of nationals of a member state in the territory of another member state are to be prohibited, and Article 49, the first paragraph of which provides that restrictions on freedom to provide services within the community are to be prohibited in respect of nationals of member states who are established in a state of the community other than that of the person for whom the services are intended. According to the court's case law, Articles 43 and 49 are specific expressions of the principle of equal treatment. The prohibition on discrimination on the ground of nationality is also a specific expression of the general principle of equal treatment. In its case law relating to the community directives on public procurement, the court has stated that the principle of equal treatment of tenderers is intended to afford equality of opportunity to all tenderers when formulating their tenders, regardless of their nationality. As a result, the principle of equal treatment of tenderers is to be applied to public service concessions, even in the absence of discrimination on the ground of nationality. The principles of equal treatment and non-discrimination on grounds of nationality imply, in particular, a duty of transparency which enables the concession-granting public authority to ensure that those principles are complied with. That obligation of transparency, which is imposed on the public authority, consists in ensuring, for the benefit of any potential tenderer, a degree of advertising sufficient to enable the service concession to be opened up to competition and the impartiality of procurement procedures to be reviewed. Now, the court goes on to deal with the application of the TECAL exception at paragraph 56 and following. Secondly, the Italian Republic, Stadtwerk Brixen and Gemeinde Brixen contend that the application of the rules of the treaty and of the general principles of community law to a situation such as the main proceedings is precluded by the fact that Stadtwerke Brixen is not an entity independent of that municipality. In support of that argument, they rely on TECAL. In that regard, it is important to recall that in TECAL, the court held that the 93 directive coordinating procedures for public supply contracts is applicable where a contracting authority, such as a local authority, plans to conclude in writing with an entity which is formally distinct from it and independent of it in regard to decision-making, a contract for pecuniary interest for the supply of goods. As regards the existence of such a contract, the court stated in paragraph 50 of TECAL that in accordance with Article 1A of the directive, it is in principle sufficient if the contract was concluded between, on the one hand, a local authority, and on the other hand, a person legally distinct from that local authority. The position can be otherwise only in the case where the local authority exercises over the person concerned a control which is similar to that which it exercises over its own departments, and at the same time that person carries out the essential part of its activities with the controlling local authority or authorities. The court has confirmed that the same considerations apply to Directive 9250 on public service contracts and to Council Directive 9337 concerning the coordination of procedures for the award of public works contracts. Those considerations are based on the premise that the application of the directives depends on the existence of a contract concluded between two distinct persons, see TECAL, yet the application of Articles 12, 43 and 49, as well as the principles of equal treatment, non-discrimination and transparency associated with them, does not depend on the existence of a contract. As a result, the considerations developed in the case law cited in paragraphs 56 to 9 of this judgment do not apply automatically either to those provisions of the treaty or to those principles. Nevertheless, it must be held that those considerations may be transposed to the treaty provisions and to the principles which relate to public service concessions excluded from the scope of the directives on public procurement. Indeed, in the field of public procurement and public service concessions, the principle of equal treatment and the specific expressions of that principle, namely the prohibition on discrimination on grounds of nationality and Articles 43 and 49, are to be applied in cases where a public authority entrusts the supply of economic activities to a third party. By contrast, it is not appropriate to apply the community rules on public procurement or public service concessions in cases where a public authority performs tasks in the public interest for which it is responsible by its own administrative, technical or other means without calling on external entities. Consequently, in the field of public service concessions, the application of the rules set out in Articles 12, 43 and 49, as well as the general principles of which they are specific expressions, is precluded if the control exercised over the concessionaire by the concession-granted public authority is similar to that which the authority exercises over its own departments, and if at the same time that entity carries out the essential part of its activities with the controlling authority. Since it is a matter of derogation from the general rules of community law, the two conditions stated in the preceding paragraph must be interpreted strictly, and the burden of proving the existence of exceptional circumstances justifying the derogation of those rules lies upon the person seeking to rely on those circumstances. See Stat Haller.
Yes.
Now, the ground on which in this particular case, the Tekal test failed, what they've said there is, in substance, that the Tekal case applies to treaty as well as to directive cases, but in applying it, they held that the control test was not satisfied, and the grounds on which they did that appear from paragraphs 67 to 70. By contrast, Stadtwerke Brixen became market-oriented, which renders the municipality's control tenuous. Militating in that direction are A, the conversion of Stadtwerke Brixen, special undertaking, into a company limited by shares and the nature of that type of company. That appears to have been because it was envisaged that at some future stage part of the company might be floated off. B, the broadening of its objects, the company having started to work in significant new fields, particularly those of the carriage of persons and goods, as well as information technology and telecommunications. It must be noted that the company retained the wide range of activities previously carried on by the special undertaking, particularly those of water supply and wastewater treatment, the supply of heating and energy, waste disposal and road building. So B appears to be making the point that the company was engaged in activities other than those germane to the public functions of the authority.
Is that the function test rather than the control test?
That is something which may impact on either, although they have different purposes. If you have a substantial number of private customers, it appears to have been considered in this case that would militate against the satisfaction of the control test.
Is the function test, sorry to interrupt you, just to clarify, is the function test directed to what is actually happening, whereas the control test is related to what can be done to control what will happen?
Well, the control test is addressed to the position of the public authority, whereas the function test is addressed to the position of the supplier.
Yes.
The question whether a prospective event inconsistent with the application of the test has only been considered by the ECJ in the context of the control test. And in cases where the control test is not satisfied, they generally don't go on to deal with the function test.
Yes.
But I mean, this would fall flatly foul of your essential function must be to supply the controlling authority.
Well, Lord, I'm not sure that it is inconsistent with it.
Sorry?
What they are saying is that in this case, there were functions other than those of supplying the local authority, and that would be inconsistent.
Yeah.
I'm sorry, but I accept that the presence of a significant number of private customers is not consistent with either the function test or, in fact, the control test on this authority. I'm not disputing that at all.
Yeah.
Oh, I was jumping ahead very fast, and I don't want to divert you, but one of the questions we're going to have to look at is the breadth of the objects clauses in the memorandum.
Yes, we are. That's
and this may have a bearing on that.
Yes, it does. I mean, that's one reason why I'm citing it to your lordship. And my learned friend, of course, submits that both tests fail.
Yes.
There is a category in particular of affiliate of a local authority that may be ensured, and I'll have to address your lordships on the significance of that.
Well, that's B.
C, the obligatory opening up of the company in the short term to other capital. That is actually essentially the same point as A. The facts in this case were that the reason why it had been converted into a company limited by shares was so that some of the shares could be transferred to contributors of private capital. D, the expansion of the geographical area of the company's activities to the whole of Italy and abroad. That clearly would be inconsistent with the function test. The considerable powers conferred on its administrative board with in practice no management control by the municipality. 68. In fact, as regards the powers conferred on the administrative board, it is clear from the decision of reference that the statutes of Stadtwerke Brixen, particularly Article 18, give the board very broad powers to manage the company, since it has the power to carry out all acts which it considers necessary for the attainment of the company's objective. In addition, the power, under the said Article 18, to provide guarantees up to €5 million, or to effect other transactions without the prior authority of a shareholders' meeting, shows that the company has broad independence vis-à-vis its shareholders. The decision of reference also states that the Gemeinde Brixen has the right to appoint the majority of the members of Stadtwerke Brixen AG's administrative board. However, the referring court notes that the control exercised by the municipality over Stadtwerke Brixen is limited essentially to those measures which company law assigns to the majority of shareholders, which considerably attenuates the relationship of dependence which existed between the municipality and the special undertaking Stadtwerke Brixen. In the light, above all, of the broad powers possessed by the Stadtwerke Brixen's administrative board, where a concessionaire enjoys a degree of independence characterized by elements such as those noted in paragraphs 67 to 9 of this judgment, it is not possible for the concession-granting public authority to exercise over the concessionaire control similar to that which it exercises over its own departments. Now, as I think is plain from that section read as a whole, it is the combination of these factors which was fatal to the control test's application in this case. As your lordships will see, there are cases in which some of the factors listed at paragraphs 67 to 69, although not all of them, were present, which were held to be quite consistent with the control test.
As assumption, I'm not quite clear what sort of new departure is evinced by this case. It seemed to me that they were applying Stadthalle, obviously in the context of not the directive but the treaty,
Yes.
and then applying that to the facts of that particular case. But what is new about this case?
What is new about this case is that it's applying it for the first time to a situation where the directive doesn't apply.
Yeah.
And that is relevant in the present case because the main cases which deal with the question, it's relevant for a number of reasons. The most important is this. The main authorities in the ECJ which say that collective control is enough are authorities on concessions. They are authorities in which the court has said the test is exactly the same, whether it's a concession not governed by the directive or something else which is. But it happens that the authorities which deal with collective control directly are concession cases. Now, my learned friend says none of those apply in a case where the directive is the source of the obligation. They only apply in cases that they're confined to cases where the treaty applies directly. My reason for taking your lordships to this case and to one or two other cases which we'll be looking at is simply to demonstrate that that's a distinction that just doesn't work.
The case is also of interest to Mr. Howell, I suspect, because of the rather careful analysis of the scope of the powers given to the board, the lack of control over the board, and the breadth of the objects. And we'll come on to that at a later stage.
My learned friend says that some, at any rate, of these criteria are present here.
Yes.
Now, in particular, and this is what the Court of Appeal primarily relied on, it's the independent functions of the board. Now, Parking Brixton does, of course, itself point out that any arrangement under which you set up a company or to carry out certain functions involves giving a certain amount of decision-making autonomy to that company. It's a question essentially of degree, and on control, your lordships will, I suspect, find assistance, particularly in the Coditel case when we get to it, because that was a case in which the court acknowledged that the widest possible managerial discretions had been conferred on the governing council of a subordinate corporate entity without adversely impinging on the application of the control test. And they did that, as I shall say, because the existence of that management discretion was not inconsistent with the subordinate entity being wholly concerned with the performance of the public functions of the local authority. And it's the critical importance of the question, is there a lack of control in some respect which prevents one from saying, here is a subordinate body wholly identified with the public functions of the public authorities? Not a point that I extract from this case, but it's a point which will emerge from the cases as they develop. Now, what matters about Parking Brixton, in addition to the point about the criteria and the application of the same principle to a case where the directive didn't apply, is also the way in which it was subsequently analysed and applied in later cases. The next case I would ask your lordships to look at, if I may, is Carbo Telmo, which is another case from Italy in volume 4 of the authorities bundle, tab 26.
Sorry, I missed the number. Tab 26.
Tab 26. Now, this case, and the one which I'm going to cite next, which is Asemfo, are interesting cases because they essentially show two sides of the same coin. In Carbo Telmo, there was a contract for the purchase of heating equipment and facilities, which was placed by the Italian commune of Busto Arsizio with a consortium company in which it owned 99.98% of the shares, the others being owned by other local authorities. Asemfo, the next case I'm going to come to, is a case in which the reverse was true. The contracting authority held a trivial proportion of the shares, and a non-contracting member of the consortium owned 99%. And what is interesting is that one will see the same principles applied in both cases. Now, if your lordships return first to Advocate General Stix-Huckle at paragraph 31, under the heading Legal Assessment of Public-Private Undertakings, principle, the facts of the main proceedings exhibit a further characteristic that distinguishes them from the situation at issue in Stadthalle. This case does not concern a semi-public entity, but an entity, or more precisely its parent company, in which no private undertakings hold shares. This is not apparent from the order for reference, but from other documents before the court. Furthermore, the shares owned by other parties amount to only 0.02% of the capital. Since those residual shares are held by other municipalities, i.e. public bodies, the entity in question is a public-public undertaking or a public-public partnership. If the circumstances of this case are compared with the court's previous case law, the following picture emerges. On the one hand, there is a fundamental difference between this case and Stadthalle, which concerned a semi-public entity. On the other hand, there is a clear parallel with Tekal, which concerned a public-public entity. In the latter case, the entity which was to perform the procurement contract, namely AGAC, did have its own legal personality, but had been set up by a number of municipalities. Further support for the application of the Tekal exception to public-public entities, in addition to the judgment in Tekal, as already explained, is the fact that in the judgment in Stadthalle, The deciding factor for the court was that private undertakings pursue different interests from local authorities. However, this case is concerned only with the participation of municipalities and not with the interests of private parties. Since municipalities pursue objectives in the public interest, it could be assumed, at least on first sight, that the control criterion, even on a strict reading of it, is satisfied. That is certainly the case if the condition in respect of identity of interests is understood as meaning that such identity obtains automatically in the absence of private interests. Of course, the possibility cannot be discounted, and it's confirmed by their activities as economic operators that local authorities may represent a variety of interests. In such cases, there is no longer identity of interests. Now, one there sees this concept of identity of interests, i.e., identity of interest with the public interest of the authority, as being what the control test is actually getting at. Now, the attempt to invoke the exception failed in Cabo Termo because, in spite of the fact that the relevant commune held almost all the shares, the constitution of the company contained no reserve power in the shareholders to give directions to the board, such, for example, as the shareholders of an English company will normally have under the special resolution procedure. And your lordships will find the reasoning at paragraphs 36 to 40 of the judgment itself. Paragraph 36, in order to determine whether the contracting authority exercises a control similar to that which it exercises over its own departments, it is necessary to take account of all the legislative provisions and relevant circumstances. It must follow from that examination that the successful tenderer is subject to a control enabling the contracting authority to influence that company's decisions. It must be a case of a power of decisive influence over both the strategic objectives and significant decisions of that company. I think I may have forgotten to show your lordships paragraph 65 of Parking Brixton, because this, of course, is one of the other reasons why it's a relevant case. It identifies the criterion as being not, so to speak, day-to-day control, but decisive influence over strategic objectives and significant decisions.
Yes. That's 65, you say?
Yes, it is. Over the page, 37, the fact that the contracting authority holds, alone or together with other public authorities, all of the share capital in a successful tenderer tends to indicate, without being decisive, that that contracting authority exercises over that company a control similar to that which it exercises over its own departments, as contemplated in paragraph 50 of Tekal. It is apparent from the case file that the statutes of AGESP Holding and AGESP confer on the board of directors of each of those companies the broadest possible powers for the ordinary and extraordinary management of the company. Those statutes, and this in our submission is the critical point, those statutes do not reserve for the commune of Busto Arsizio any control or specific voting powers for restricting the freedom of action conferred on those boards of directors. The control exercised by the commune over those two companies can be described as consisting essentially of the latitude conferred by company law on the majority of the shareholders, which places considerable limits on its powers to influence the decisions of those companies. Moreover, any influence which the commune might have on AGESP's decisions is through a holding company. The intervention of such an intermediary may, depending on the circumstances of the case, weaken any control possibly exercised by the contracting authority over a joint stock company merely because it holds shares in that company. It follows that in such circumstances, subject to that being verified by a court adjudicating on the substance in the main proceedings, the contracting authority does not exercise over the successful tenderer for the public procurement contract at issue here a control similar to that which it exercises over its own departments. Now, my lords, thus far, in those cases which concerned consortium companies, the public authority was the dominant shareholder of the contractor. And the first test of the concept of collective control by a consortium, none of whose members had individual control, or none of whose relevant members, is the case I want to turn to now, which is Asemfo, which is in volume 3 of the authorities at flag 23. Now, this case, the proposition which I'm relying on is was accepted in this case, although it is not exactly screamed from the rooftops in the language of the decision. But it was certainly treated in subsequent cases which directly deal with the question of collective control. It was treated as having established that proposition for the first time. Now,
tab 23.
tab 23 in volume 3.
Yeah.
Now, my lords, the Asemfo case was not a directive case, it was a treaty case. In this case, this was not because it concerned a service concession, it was because the obligation of the supplier to supply the relevant local authority was an obligation sounding wholly in public law. There was therefore no contract. The procurement obligations, consequently, arose directly from the treaty. Now, the supplier in this case was a public sector entity in which the Spanish state held 99% of the shares, and the remaining 1% was divided between 4 local authorities, each of whom held 0.25% of the shares. One of those local authorities was the authority which had procured services from it without prior advertisement of the contract. So, as a matter of company law, clearly the control which a 0.25% shareholder held over the entity was negligible. What was submitted was that the only entity which could be said to control the supplier in the Tecai sense was the Spanish state, and since that was not the contracting entity, that was an end of it. That proposition was not accepted. The problem was stated by the Advocate General at paragraph 38 of his opinion. However, the factual and legal situation, he says, underlying the questions heard in this case, differs in 2 respects from the judgment cited in footnote 7, and that is Stat Haller and Cabo Telmo. The Spanish state administration and the autonomous communities, they are the local authorities, are TRAGSA's contracting authorities. TRAGSA was the supplier. TRAGSA's contracting authorities in a strictly hierarchical sense, in that TRAGSA cannot refuse the work entrusted to it by the relevant authorities, is wholly bound by the instructions and specifications of those authorities, and receives payment for its work which is calculated and determined by regulation. In short, even though its legal personality is governed partly by private and partly by public law, TRAGSA has to be characterized as an executive service of the Spanish state administration and the autonomous communities. The contractual element between the contracting authority and the contract, which always existed in the cases in which the court delivered the judgment cited above, is entirely absent here. Although TRAGSA currently carries out the essential part of its activities with the autonomous communities, the assumption that it is controlled by these territorial entities is problematical, to say the least. Its status under public law is, as is clear from the above summary, entirely or almost entirely determined by Spain's state legislature, while only 4 of the 17 autonomous communities have shares in TRAGSA on a symbolic scale. They mean a nominal scale, together accounting for less than 1% of the total share capital. It may be inferred from this that as an executive organisation, TRAGSA is indeed at the service of the autonomous communities, but not necessarily that it is controlled by them. Now, the court considered that it was controlled by them because it was controlled collectively by the 5 entities that held shares. What was held was that all 5 co-owners jointly controlled the supplier, so that the Tecai exception applied to each of them, even though none of the local authorities could control the supplier except in conjunction with the Spanish state. Now, because all 5 co-owners were public bodies, that was good enough. Now, if one turns to the judgment, the relevant question is the second question which the court answered, which starts at paragraph 46. By its second question, the referring court asks the court whether a body of rules such as that governing TRAGSA, which enables it to execute operations without being subject to the regime laid down by the directives, is contrary to Directives 93 and so on. And the first question to be considered under that head was whether those directives applied to the transaction at all. And it was held that they did not apply because Tragsa had a public law obligation to supply at regulatory prices, and therefore there was no contract. And that is the point made at paragraph 54. It must be observed that if, which is for the referring court to establish, Tragsa has no choice, either as to the acceptance of a demand made by the competent authorities in question, or as to the tariff for its services, the requirement for the application of the directives concerned relating to the existence of a contract is not met. They then went on to consider the TECAL exception on the footing that because there was no contract, the directives did not apply. Paragraph 55, in any event, it is important to recall that according to the court's settled case law, a call for tenders under the directives relating to public procurement is not compulsory, even if the contracting party is a legally distinct entity from the contracting authority where two conditions are met. And they set out the two TECAL conditions and cite the relevant cases. Accordingly, it's appropriate to examine whether the two conditions required by the case law are met in Tragsa's case. Then the control test is dealt with between paragraphs 57 and 61. As regards the first condition relating to the public authority's control, it follows from the court's case law that the fact that the contracting authority holds, alone or together with other public authorities, all of the share capital in a successful tenderer tends to indicate generally that the contracting authority exercises over that company a control similar to that which it exercises over its own departments. In the case of the main proceedings, it is clear from the case file, but subject to confirmation by the referring court, that 99% of Tragsa's share capital is held by the Spanish state itself, and through a holding company and a guarantee fund, and that 4 autonomous communities, each with 1 share, hold 1% of such capital. In that regard, the argument cannot be accepted that the condition is met only for contracts performed at the demand of the Spanish state, excluding those which are subject of a demand from the autonomous communities, as regards which Tragsa must be regarded as a third party. It appears to follow from Article 88, he refers to various Spanish decrees, that Tragsa is required to carry out the orders given to it by public authorities, including the autonomous communities. It also seems to follow from that national legislation that, as with the Spanish state, in the context of its activities with those communities, as an instrument and technical service, Tragsa is not free to fix the tariff for its actions, and that its relationships with them are not contractual. It seems, therefore, that Tragsa cannot be regarded as a third party in relation to the autonomous communities which hold part of its capital. Now, they're therefore, as it seems to us, giving 2 reasons for saying that the control test is satisfied. One of them is embodied in the rejection in paragraph 59 of the argument that the only outfit with control was the Spanish state. The other is based upon the fact that, as a matter of Spanish public law, when the local authorities demanded services at the regulated price, the supplier was bound to supply them. Now, the function test is dealt with briefly at paragraph 62 of the same judgment. As regards the second condition, relating to the fact that the essential part of Tragsa's services must be carried out with the authority or authorities which own it, it follows from the case law that where several authorities control an undertaking, that condition may be met if that undertaking carries out the essential part of its activities, not necessarily with any one of those authorities, but with all of those authorities together. So the logic of accepting, as they have done at paragraph 59, that collective control satisfies the control test, is that provision exclusively to the group of persons exercising that control, but not necessarily to any one of them, is sufficient to establish satisfaction of the function test.
Sorry, so any one will do, so long as it's within the collective body.
Yes. The summary of the decision is at paragraph 65. It follows from the entirety of the foregoing considerations that the reply to the second question must be that a body of rules such as that governing Tragsa, which enables it as a public undertaking acting as an instrument and technical service of several public authorities, to execute operations without being subject to the regime laid down by those directives is not contrary to the directives in question, since first, the public authorities concerned exercise over that undertaking a control similar to that which they exercise over their own departments, and secondly, that such an undertaking carries out the essential part of its activities with the same authorities. Now, my lords, a decisive step in the same direction was taken in 2008 with the important decision of the European Court in Coditel, which your lordships will find in volume 4 of the bound authorities at flag 27. A decision which I think can fairly be said to have broadened the approach to many aspects of this test. This judgment was not considered by Mr. Justice Brent because it came out after he had given judgment, but before the Court of Appeal, and the Court of Appeal did consider it. Its authority for two propositions. First of all, its authority for the proposition that the existence of a wide managerial discretion in a vehicle company is not in itself a reason to hold that the control test isn't satisfied. That, of course, is provided that the vehicle company is not trading in the commercial market, is not, as they put it, market-oriented, but is simply engaged in furthering the public functions of the authorities with whom they contract.
Yes.
The second proposition is that in this case the European Court formally decided what was implicit, if not explicit in its earlier decisions, namely that shared control is sufficient control for the purposes of the TECAL exception, even if it means that no one authority has control on its own. Now, something about the facts in Codital. It was about the status of a corporation called Brutele. Brutele was a cooperative of a number of local authorities in the Brussels area who all operated municipal cable TV networks. And Brutele operated the networks on behalf of the authorities in return for a right to charge subscribers. Now, the commune of Uccle was not initially a member of the consortium, the Brutele consortium, but it became a member for the specific purpose of making use of Brutele's services. The transaction was classified as a concession because Brutele derived its revenues from charging on a commercial basis members of the public who subscribed to the cable TV service. For that reason, this was a case directly governed by the treaty and not by the directives. The facts about Brutele were that it was run by a governing council, so-called, of representatives of the participating local authorities who had, on the findings, the widest managerial discretions. It seems that no one local authority had any power of control over Brutele at all. The only control was collective control. Now, the opinion of the Advocate General, which was in fact adopted by the Court, is of some interest in that it not only contains the usual summary of the jurisprudence to date, but shows the growing sensitivity of the Court to the practical requirements of cooperation between public authorities. Now, I see your Lordship looking at the clock.
No, it's really just...
1 o'clock will strike halfway through my citation of this case. If your Lordship's...
Well, please go on. I wasn't trying to inhibit you at all. I was just seeing how much more time there was to finish the case. Obviously we can't, but we can make progress.
My Lord, yes. My Lord, the Advocate General's opinion begins on page 8460, and the arguments which he was considering are summarised at paragraph 1 and in two other places I shall come to. The reference by the Conseil d'État in Belgium concerns the scope of community procurement law. It concerns the question whether procurement law is applicable where a regional authority, in this case a municipality, delegates the management of its cable net television network to a body that is a purely intermunicipal cooperative entity, with the involvement of that municipality, yet without drawing on any private capital. The present case involves intermunicipal cooperation in the form of a cooperative, and the questions first submitted by the referring court concern the first of the well-known TECAL criteria, control similar to that exercised over an entity's own department. Your Lordships would turn on from there to paragraph 29. Parties' submissions is the heading. Paragraph 29, essentially all parties agree that this is a case involving the sector of the award of public concessions that is not subject to the directives on procurement, but to the general requirements of transparency, that is to say, under the treaty. And then at paragraphs 33 and 34, summarising the argument, Coditel points out that before affiliation to Brutile, the municipality of Uccle had no relationship with the cooperative, with the result that the TECAL case law is in no way relevant. Moreover, the municipality of Uccle holds only 8.26% of Brutile's shares, 76 out of the 920. In addition, Brutile provides its services such as cable television, telephone and internet on a commercial basis and in competition with other private sector service providers. The internal structure of Brutile is essentially similar to the internal structure of a private undertaking. The municipality of Uccle does not have the capacity to control Brutile. Rather, it is questionable whether there can be any actual collective control by the cooperative members owing to the large number of members and possible divergences of interest. In the light of the judgment in Carbo Termo, it is not a determinant factor that 100% of the capital of Brutile is owned by municipalities and regional authorities. In that connection, it is in particular not sufficient that Uccle was granted an operating subsector. The Commission also deals in its submissions with the internal decision-making structures of Brutile and considers that in that connection, it is unable to discern a power of decisive influence. That, of course, was the Parking-Brixton test, as the footnote shows, on the part of an individual municipality such as Uccle. Brutile's board of directors possesses wide-ranging powers and in particular also determines tariffs. The municipality of Uccle has in each respect only a shared influence and is not freely in a position to enforce its will, which is, however, a precondition for satisfying the first TECAL criterion. Now, if one turns from there to the remaining parts where she considers the question of principle, the Advocate General thought that the absence of a private sector participation combined with the principle implicit in earlier decisions that collective control was enough, was decisive in favour of the transaction, and that was a view which was adopted by the Court. The Advocate General's consideration of the principle starts at paragraph 49 of her opinion. Since at the material time, in relation to the events in the main proceedings concerning the award of service concessions by public agencies, no directive coordinating the proceedings was in existence, the consequences under community law of the award of such concessions fall to be examined as before, solely in the light of primary law and in particular the fundamental freedoms laid down in the treaty. Accordingly, requirements are imposed concerning equal treatment and transparency for the award of public service concessions, in particular in regard to the prohibition on indirect discrimination. Case law permits an exception for quasi-in-house performance of tasks, beginning with TECAL, and further elaborated and applied to all community provisions in the sector of public contracts or public service concessions, in the case of a procedure that is configured in such a way as to constitute an internal administrative measure. Under settled case law, a call for tenders is not mandatory, even if the contractual partner is an establishment legally distinct from the public awarding body, if two preconditions are met, and they set out the TECAL conditions. And turning over the page to paragraph 53, it is unmistakably to be inferred from the settled case law since Stat Haller that semi-public undertakings are in no way deemed to be entities over which similar control is exercised over their own departments, irrespective of the degree to which the private capital involvement is a minority holding. In that connection, it is enough for there to be a possibility of private capital involvement, even if there is as yet none. An assignment to private persons of shares occurring shortly after the award must also be taken into consideration. At 55, however, it is plain from this may
I wonder
perhaps
whether
be
we
a-
should just
a
pause there.
sensible point
We've
to break.
got the proposition of 53 clearly stated.
Yes. My Lord, we now have the missing pages of the articles of the treaty. Perhaps we'll supply
Yes, but
those
perhaps they could be
also.
put into our files
I will arrange for that to
during
be
the
done.
adjournment.
Yes.
Well, we'll see you at 2 o'clock.